Exclusive possession of the marital home in an Illinois divorced living together during a divorce is rarely sustainable. Tensions rise, conflicts escalate, and the stress of cohabitation with a soon-to-be ex can become unbearable. In Illinois, courts have a legal process that can determine which spouse stays in the marital home and which one must go. The law on exclusive possession in Illinois, a spouse can be temporarily evicted from the marital home if the court finds that continued cohabitation threatens the physical or mental well-being of either spouse or their children. This isn't limited to physical abuse. Mental or emotional strain can also justify such a decision. Courts are guided by Section 750 ILCS 5500 C2, which allows for temporary exclusive possession of the marital residence after a verified complaint and full hearing. A lawyer can file the petition, and a judge will weigh the emotional and physical impact on both spouses. One of the main factors the court considers is hardship. If one spouse would suffer more from leaving the home, especially if they're caring for children, they are more likely to be granted exclusive possession. Ownership or the lease agreement doesn't determine who gets to stay. Even if one spouse is on the title or lease, both parties still have equal occupancy rights until the court decides otherwise. Getting exclusive possession. How it works: when one party requests exclusive possession, they must demonstrate harm or hardship. This process begins with a verified petition or complaint. The court may order a full hearing unless there's good cause to waive it. But the reality is, waiting for a hearing can take months. In that time, the ability or inability to live together often becomes a factor in whether the request is granted. In some situations, spouses seek orders of protection to speed up the process. An emergency order can provide temporary exclusive possession, and if granted, a follow-up hearing must be held within 14 days. During this hearing, the court balances hardships again, giving priority to the well-being of any children involved. Even after being removed from the home, the spouse may be allowed back briefly to collect personal belongings, medications, and other essential items. Understanding the process from start to finish. The process of securing exclusive possession of a home during divorce happens in stages. Initially, temporary possession may be granted either through a court motion or an emergency order of protection. These are revocable and do not affect the final distribution of the home. When the divorce is finalized, the court enters a judgment for dissolution of marriage. At this point, property marital and non-marital is divided. If one spouse owned the home prior to the marriage and kept it solely in their name, it remains their non-marital property. However, the court often awards the home, or the right to live in it, to the spouse who will have primary custody of the children. The law emphasizes stability for children and recognizes the importance of maintaining a consistent home base. An attorney can help argue for a fair distribution under the principle of equitable, not necessarily equal division. Illinois courts consider economic circumstances, caregiving responsibilities, and the needs of minor children. Final orders related to the home cannot be modified unless there is evidence of fraud or another serious legal justification. If you're going through a divorce and need clarity about staying in your home or asking your spouse to leave, understanding the legal process is critical. Contact the law office of Russell D. Knight to speak with a lawyer or attorney who can guide you through your options. Call 773-334-6311 or visit us at 1165 North Clark Street, number 700, Chicago, Illinois, 60610, United States.